आवाज क्लियर है तो नहीं।
खड़ी है ना।
Good evening, colleagues and friends, and all those who have joined us in support today. On behalf of SNG and partners, I welcome all of you to the virtual conclave on the intricate web of recoveries and asset discovery, decoding global legal, regulatory, and enforcement challenges. I am Nipun Bhatia, President, Strategic Legal Management at Legal League Consulting, India's first management consultants to global legal industry, and also the co-presenters to this virtual conclave. I'll be your host for this evening and also be the medium to take your questions live to the eminent panelists we have. Please write your questions in the chat box as we go along. And yes, when we are finishing the panel discussion, I'll straight away take your questions to the panelists. But before we move on, let me first of all request Ms. Vitika Anand, the founder and CEO of Legal League Consulting, who are also the co-presenters of this virtual conclave, to give the welcome address and share with us about the uniqueness of this initiative started by SNG and partners. Over to you, Vitika.
Thank you, Nipun, so much. Good evening, everyone. And let's see some smiles on everybody's faces because it's going to be a very interesting evening. I am truly excited to be part of this unique initiative started by SNG and partners. And I am sure we have a riveting evening ahead of us. For all of us, the topic of the conclave itself is really intriguing as we see such stories mostly in movies, web series, documentaries, and of course, news. But I truly appreciate the team of SNG and partners who are decoding the intricate web of recoveries and asset tracing and showing all of us the real perspective. As the founder and CEO of Legal League Consulting, I am proud to co-present this conclave with the firm that has unmatched knowledge on the subject and would do absolute justice to the topic of discussion today. Managing partner of SNG and Partners, Mr. Rajesh Narayan Gupta, has covered an exemplary journey in the field of banking and finance, commercial laws, real estate, and private client practice. Being a true visionary, he has laid the foundation of virtual conclaves as part of SNG Partners' commitment to spread knowledge and awareness. This conclave is the brainchild of Mr. Amit Agarwal, partner and head of corporate practice at the firm, and a truly dedicated professional. He has been at the forefront of several complex transactions and is star lawyer in the field of banking and finance, corporate and commercial laws, capital markets, and private equity. I'm a witness to hard work he and his team has put up for curating interactive platform where veterans can not only discuss the issues and challenges in recovery and asset tracing, but also explore solutions. We have a fantastic panel which is graced by exemplary panelists. I would request the audience to participate in the discussion wholeheartedly and make the most of chance to interact with our eminent panel. I wish you guys all the best. Thank you.
Thank you so much. Thank you so much, Vitika, for those amazing words at the welcome address. But before we move ahead to introduce the panel, let me just take a quick moment to introduce our media partners' latest laws and thank them for their coverage and support in making this conclave reach the right people. To discuss some extremely pertinent and relevant issues on recoveries and asset discovery, particularly in the light of current economic scenario across the globe, we have a legendary panel of experts, and I'm excited to introduce you to these stalwarts and iconic achievers from very diverse fields. So let me just take these honors one by one. First of all, I have the privilege of welcoming Mr. Rajwardhan Sinha, Joint Commissioner and Head of EOW Mumbai, India. Mr. Sinha is a decorated senior IPS official and has investigated several matters related to financial fraud, including PMC bank case, NSEL scam, QNet, and many others. He's a true braveheart, and he was amongst the first officers to enter the Taj Mahal Kolaba during the infamous terrorist attacks in Mumbai. Welcome to the panel, Mr. Sinha. We are pleased to have you on the panel. I also next welcome Mr. Ravichandran Ramasamy, Principal Director of Income Tax Investigations, Bengaluru, holding search and seizure operations. With more than 3 decades of experience, Mr. Ramasamy previously worked as Director of Income Tax, Intelligence and Criminal Investigation, Karnataka and Goa, handling intelligence gathering, data mining operations, and data analytics project of CBDT during the period of demonetization and income disclosure scheme. He has been a part of various committees constituted by the Ministry of Finance for framing legislation under the Prevention of Money Laundering Act and cross-border taxation. As a part of All India operation on Bitcoin exchanges, he has handled investigation on Bitcoin exchanges and investors, resulting in detection of huge amounts of undisclosed income. Sir, it's truly our honor to have you with us on the panel today, and we really welcome you to this conclave. Also gracing the panel is Mr. Gurpavan Singh, founder of Iris Private Limited, India. Mr. Singh is currently the president of the company and has approximately 25 years of experience of handling forensics, intelligence, investigations, and assets handling. He has worked closely with many government agencies, the RBI, top financial institutions, and investors. His work includes trans-border asset recoveries, fund trails, live monitoring as per the authorized fund usage, and identifying trouble signs before the trouble hits the company. Sir, it's a pleasure to have you on the panel today. We welcome you. I'm also truly honored to have Mr. Paul Gare, partner TLT LLP UK. Mr. Gare is a partner in the Financial Services Disputes and Investigations team at the firm. He advises on disputes involving a range of complex financial products, trade finance issues, cross-border enforcement, fraud, insolvency, and contentious regulatory matters. Most recently, he has been acting for 13 Indian banks enforcing their debt recovery tribunal judgment against Mr. Vijay Mallya, which also included registering the judgment with the English courts and securing a worldwide freezing order against Mr. Mallya. Welcome to the panel, Mr. Gare. Please also join me in welcoming Mr. Nick Wood, Grant Thornton, UK. Mr. Wood has specialized in insolvency, asset tracing, and recovery for over 30 years. Recently, he has been involved in insolvency and asset recovery assignments in India, Africa, and the Middle East, acting for states and commercial banks on their non-performing loan portfolios. He's a leading expert in using fund solutions in insolvency situations where there are no assets to fund the pursuit of valuable claims and disputed assets. His team has recovered over $3 billion and misappropriated assets in the last 7 years. Welcome to the panel, Mr. Wood. And finally, I'm truly honored to introduce Mr. Amit Agarwal, partner SNG and Partners India. Mr. Agarwal is a practicing corporate lawyer and a qualified company secretary with a career span of over 2 decades. He heads the corporate practice at SNG and Partners and specializes in banking and finance, M&A, and insolvency laws. The area of his expertise include insolvency practice, and which ranges from conducting high-level structuring to strategic execution of acquisition of the corporate debtor. He is consistently rated as a leading banking and finance lawyer in India by several international publications like the Chambers and Partners, IFLR, and the Legal 500. Well, with such a power-packed panel waiting to discuss some very interesting issues, I'm not going to hold you guys back, but I would just like to thank Mr. Amit Mohan, IRS Joint Commissioner of Income Tax, Mumbai, for all the help in organizing and facilitating this webinar. And now I'm handing over the baton to Mr. Agarwal. Over to you.
Thank you, Nipun. Thank you, Bitika, for your kind words. I'm overwhelmed. Good evening, ladies and gentlemen, and a very, very warm welcome to the second and the final edition of this virtual conclave focused towards asset tracing and recovery. When I was very young, sometime in 1987, Oliver Stone directed the very famous Hollywood movie of its time called Wall Street. Michael Douglas played the character of a rogue stockbroker, Gordon Gekko. A famous dialogue of Gordon Gekko in that movie, which I still remember, is, "Greed is good." Greed or desire to grow is definitely good, but it needs to be kept in check. With the opening of the Indian economy, Indian corporates also started spreading their wings. While this added to the growth, but in the recent past, a very large number of non-performing assets and the defaults surfaced in the Indian financial sector. There have been cases where one has enriched himself at the cost of the other. Banks and financial institutions have been defrauded by the persons in control and management of corporate houses by siphoning of funds. I'm sure you would have heard stories or the news items about some big corporate honcho being seen in London, Paris, Monte Carlo, whereas bank officials and the enforcement agencies are looking for him for a white collar crime. However, in the recent past, Indian legal system has made significant development to nab such accused who are guilty of white collar crimes. With the passing of the Fugitive Economic Offenders Act, Indian regulatory authorities now have those teeth which were somehow missing in our previous enactments. Some of you may be aware that Mr. Vijay Mallya is the first person to be declared as the fugitive economic offender. He was soon followed by Mr. Nirav Modi. Mr. Vijay Mallya has already lost his plea appeal against extradition to India. His extradition is now in progress. One must remain mindful that the extradition process is extremely time-consuming and a process-driven exercise. A lot depends upon the kind of international relation Indian government has with that country. It also depends upon the kind of the crime and the severity of it, and whether India has an extradition treaty with that government or not. In today's discussion, this panel will discuss some of the critical aspects relating to the asset recovery and enforcement. So let's start the panel discussion. And at the start of this, I would like to ask my first question to Mr. Rajvardhan Sinha. Good evening to you, sir.
Good evening, Amit.
We have seen that in most of the default cases, there is an element of a fraud committed by certain promoters, which is discovered later. I want to understand from you, more from the audience perspective, that what is the trigger for an economic offense wing team to start investigation in such cases? And could you also give us some insight on how the whole investigative process is run?
Thank you, Amit. And big hello to all the panelists. Amit, the issue regarding as far as triggering or start of the investigation is concerned, I'll take the first thing first. You are aware that most of the economic offenses in India are still covered by the classical Indian Penal Code, which has ample scope for covering almost all the cases, because no matter what, the element of cheating, forgery, criminal misappropriation, criminal breach of contract is always there. So the issue with us is that by the time the cases come for criminal prosecution, either it is too late, or at the times, much of the valuable, what we can say, the golden hour, as far as starting the investigation is concerned, is lost. Having said that, we can't, in most of the cases, take the cognizance suo motu, because most of the white-collar crime starts initially by criminal breach of contract or by discovery of some massive fraud. And this fraud, cheating, or breach of contract happens against somebody else. So as long as either of the parties don't approach us, it becomes very difficult for us to start a case. And we have seen that in most of the cases, the initial approach of the affected or aggrieved party is to somehow get back the value or the assets which they have lost. They have this notion that going to the court or going to the police will take a lot much of a time. So it is always better to go for some kind of a settlement than approaching the civil court process or the criminal process. So this is one of the biggest impediment. And by the time the cases come to us, most of the money is either lost, or the known or important fugitives have left the shore of the country. So there are certain exceptions. I will come to those exceptions later. But since this webinar is more about big or so-called publicized crimes, where the defaulters have siphoned off the state's money or the public money or the money of certain known entities at large. So in such cases, what is the problem is that we don't have a way out but to wait for somebody to come forward and complain. Having said that, I can tell you that now in India, even the laws related to public cheating in the way of chit fund scam, or where some kind of deposit is asked for or some investment is asked for with a massive return, say 100%, 150%, or even 75%. And in these kind of returns, to give you some example, like in the early 90s, there were a lot of plantation schemes coming across the country where if you invest certain money, you will own a tree or something, and then gradually when it is cut, you will get a massive return. Or you own a goat, or you own a emu, or many these kind of frauds. It is not quite back away when a famous Peak Asia case had come to light, where this company had gone into sponsoring some of the very, very popular events in the country and had gone for a massive publicity. And it appeared that it is some kind of a very clear-cut, government-recognized entity or a policy where anybody can earn a massive amount of money sitting at home. And the total loss of the collective people was in crores. Today, even also, we are dealing with one particular company, I will not name the company, where the total number of investors are more than 53 lakhs. So if you go by the particular individual investment, it may not be more than, say, 5,000 or 10,000. But when you go into the lakhs and lakhs of investors, the amount that goes into it runs into thousands of crores. So there are challenges in these kind of cases. But as you pointed out, the trigger factor is that most of us across the globe wait for somebody to come forward and complain.
Thank you, Mr. Sinha. Taking a clue from what you just said with regard to the chit fund scheme and the plantation company, I would like to put my next question to Mr. Ramasamy. Mr. Ramasamy, India has discovered some good number of MLM and the Ponzi schemes in the recent past, where scores of individuals have been defrauded. Mr. Sinha has also mentioned about a company where 53 lakh investors or the depositors were there. People in such scenarios who are in control and management of such companies, after a point, would defraud the people and leave the company, leave the country. I want to understand, what are the steps taken by government agencies to discover the money laundered by them or the proceeds of crime, as we call under the Prevention of Money Laundering Act? Because by defrauding the customers, they have created the assets for their own benefit. Over to you, sir.
Yeah, thank you, and welcome all the panelists. Happy to meet all of you. This multi-level marketing, Ponzi schemes, we have been, saddled with a lot many cases in Karnataka, and we used to discuss it in the state level coordination meeting with other agencies also. This is one of the major challenges for all the enforcement agencies. And most of the cases, what I have seen, even the big cases in Karnataka, is that, the so-called Ponzi operators would try to legitimize their illegal earnings by showing income tax return and trying to kind of get that thing assessed. So that's one of the ways by which, they try to show abnormal amount of returns there, and then they kind of try to buy the property in their names or their family members' name and do that. So that is one way that, we also find that even if they are not in a position to leave lock, stock, barrel outside the country, they may kind of make investments in their family members or in Binami names or fictitious names. So when we do that kind of a tracking and asset recovery, I have seen in many cases, it is quite, easy for us to go with the layering, how they have done it and what kind of a form that it got converted and who is kind of holding those kind of an asset. If it is in India, it is not a big problem because we have multiple agencies who are working together, especially that, each agency also has their own powers to attach the asset. like Mr. Rajwardhan was saying, it is like, that if the golden hour is lost, it is difficult for us, to kind of locate and trace and find out where the assets are. But I can tell you largely, I think, we have been successful in tracing the assets in India to an extent that I think that even if it gets transferred, either I can invoke this kind of a law PMLA. I think that now the PMLA has been kind of amended. So Section 8 is giving a lot of freedom. Even it also gives you the freedom to restore the assets to the investors that lost some money. And similarly, I am also kind of, that happy about the Section 447 of Companies Act. Earlier, that registrar of companies used to say the helplessness of, investing, kind of how to investigate such cases. Especially in one of those Ponzi schemes that I have found that person has opened 999 LLPs. He made all the innocent depositors as a partners, so that we can't proceed against them, as the investors who lost some money. I think they are also partners in crime. So in such cases, that do we have to put any limit on, that number of LLPs, that person can float, and what kind of liability and all that kind of issues. So that is one area that where we have been little more, kind of, we are also understanding. I'm happy that, a lot of things have happened. In fact, along with this amendment to PMLA, along with the 440, that 448 section, along with that, the section 228 of income tax, where we have that kind of a recovery of assets with international collaboration. I have seen the landscape is pretty, the clear, where whether the assets are in India or whether assets have gone abroad, we are in a position to track. In fact, we have negotiated a lot of those arrangements, that is through the double taxation avoidance agreements, that whenever we make a request under this FTNTR request that we call it, we are in a position to get to the even assets that are secreted abroad. Those information are being shared to us instantaneously. Many times that I'm in a position to get the information within 2 weeks, within a month. So that way, the kind of, the where the bank accounts are held, where the immovable property is held, where the art is being bought, all that kind of stuff, that we are in a position to get that. Then we go ahead with this MLAT, that mutual legal assistance to LOR, we send it to pursue that asset to be brought in. So, and the fugitive order also, that is, that legislation is helping us, because once you declare somebody a fugitive, then it becomes easier for us to kind of go ahead with them and attach all the assets without waiting for any kind of, the proceedings. So to an extent, I think that, then most of those Ponzi schemes, which I would say that maybe a bigger kind of a Ponzi scheme, which I have seen in Karnataka, recovery rate is something around 60 to 70%. I think to an extent that I was hoping that, that should help us. But there are a lot of regulatory overlaps that you find, because like in Karnataka, we have a separate legislation, KPID Act, which we call it. Similarly, each state has their own kind of, that act under which there are authorities who can attach the assets and auction it and recover it. That is one of the issues that, each state has a different kind of landscape on this. Similarly, the central government has brought in a separate legislation that unregulated deposits. I think that is also helping us, because wherever the multi-level state operators, there are a lot of Ponzi guys who operate across the state. So the central law will help in such a case to kind of bring everything together to track the assets in other states and also to recover them.
So you made a very good point with regard to layered structures and the assets which have been created. So I think it requires now us to go to one of our forensic players. May I request Mr. Gurpavan Singh to share his views with us? Gary, in view of the fugitives getting smarter to siphon and launder money through new innovative techniques, what new methodology and systems you guys create to catch and answer the asset discovery, recovery, and the enforcement things?
Okay, great. Thank you for the question. And I'm very glad to be on the panel along with Mr. Sinha and Mr. Ramaswamy. They are stalwarts and wonderful work they have done. And they actually have been those individual officers who have even taken innovative steps when they have even changed and forced the law to improve. A lot of actions by them. Otherwise, traditionally, our country, well, a lot of people still talk about we need privacy, the law is not existing. I think we give maximum amount of privacy. All these people who siphon and all these fraudsters enjoy an unprecedented privacy of creating 3 PAN numbers and not getting to know, creating more than one Aadhaar, or maybe having all the will of how they want to siphon and whether they want to make assets within the country or outside. So they have all this privacy already available. But okay, lighter thing aside, I generally treat these people who do such siphoning and asset making, which is illegal, into two categories. One is there are people who are blatant. They start from day one. They just want to do it. That's how they operate. And second, maybe I call them novice. What happens is, moment the company starts sliding down, it might be because of company behavior or the environmental conditions, these novice start feeling threatened, and first thing they want to do is protect themselves and financial security of their families. So at that stage, they start, but yes, they also do something bad, but maybe a little novice, they start a little late. The blatants start very early. As far as how they siphon is, I've seen it's more of a trend of your mindset and the industry you're coming from. If you are in part of IT, or if you're part of any export industry, you're used to international channels, you start siphoning through international vendors, locations, you'll start using tax havens, BVIs, and those countries so that nobody can trace back. If you're part of production, you go the traditional way of putting some more money in your vendor's pocket and take it back to your pocket. Also, I've seen, but something which is to be admired, that these people who siphon possibly also use the best of law firms and CA firms to advise them. And every next day, their complexity of the structure and how money has been siphoned has only been becoming more and more labyrinth. They very well know that if the money goes international, it'll be extremely difficult for Indian agency, because you need to go Interpol, different laws to be triggered. So take it outside. So these guys are getting smarter and smarter. And as far as tracing these assets back or tracing the fund backs, it's a mixture of science and art. And when we say it's a mixture, like if you're looking at some of the developed countries, they have very clear databases. Put a name, put an ID in, you find all the assets. And like I said, some of the Asian countries like India and others, we follow the privacy norms. So you cannot have a database where you put one name and get all the assets. So you need to get the boots on ground. You need to study the individual, his mindset, what does he like, where would he have gone, where his family is. Even I have seen the trend. Some of the people who know how to siphon well internationally, you will find they will start shipping their family members to that location in advance, start getting the dual citizenships in advance. So they not only now siphon, they even prepare for the worst, that how to run it. So we need to study the individual, the family, the operation, the spread of operations, the type of assets they will create. So everybody's not creating same type of assets. So something which I've seen, if I go into the category, everybody will keep certain liquidity. Why? Because they know when it's going to be a situation of shit hits the fan, they need that money to fight the case. So you will find a basic bunch of VAD of dollars or rupees kept to fight that battle. Then they will try to have a long-term security and safety and comfort of the families. And they're so well planned that they will even keep some money for relaunch of the business or new business. So moment you look at them, what they're doing, so that's where you start looking at the mindset, start looking at where they could have gone, where the money could have gone, where the assets can be there. And then it becomes the task of a sandwich of strategy on top, boots on ground at below, and finally digging out where exactly they've gone, what exactly they've done, and walking up to people like Mr. Sinha and Mr. Ramaswamy to take it on for much higher battles.
Thank you for your views, Gary. Very interesting. So we talked about money being siphoned off from the company, from the investors, then money exchanging hands, created structures, money goes out, asset moved out, planning being done by the fugitives. Great. So I think now it's time to go to one of our international experts and pick their brains, or as I would say, tickle their gray cells, to understand what have they seen with regard to the asset recovery or the asset tracing in the international market. So let me just first go to Nick. Nick, thank you for being with us. First question, which I just really want to put to you is, in your long-standing experience of asset tracing, where there is a web of entities which may not be linked on the face of it, but the directors or the shareholders or the employees of such directors or the shareholders are somehow connected. What are the major challenges that you come across in identifying the structure and somehow connecting those entities back to the promoters? Because your work is very important, because you are the one who will be able to raise a suspicion that this is a money which is actually belonging to a rogue guy, and the person who's holding it is just holding as a proxy. Over to you.
Thank you, Amit, and good evening, everyone. I think it's important to look at these things from both ends. So trying to identify, so from the top down and bottom up. So trying to identify where the assets are, who holds the assets. So that's the bottom end of it. And what been described by our previous speakers about looking at corporate databases, looking at things like the Panama Papers, looking at property databases, all those fruitful and things like social media. We find social media very, very effective in finding assets. We had a case where there was an individual who had said, "Look, I haven't got any assets. All my assets have gone." And we had our forensic guys looking on their social media account. The husband and wife had very small social media accounts, but the son had a good social media account, which was linked to one of his friends. And they went to that social media account, and that guy had posted a photograph of himself sitting with the son on a Ferrari in front of a villa in Dubai, saying, "This is me with my friend in front of his dad's villa, sitting on his Ferrari." And that's a good starting point. So you find out in whose name is that being held, and then that starts the trail. But you also need to start at the top end as well, and follow the money. And follow the money trail that's gone out of the banks. Where's it gone through? Which asset protection structures have been put in place in BVI, in Mauritius, Seychelles, wherever it is, and you start attacking those through legal channels, and that's the best way to attack those. And so you come to a meeting in the middle, and the most effective way is to try to get some kind of settlement. When you start these proceedings, the aim really is to get some leverage on these individuals, and that leverage is either, because as previous speakers have said, these assets tend not to be in their names, but if they're held in the wife's name or the children's names or names of associates, if you start attacking those people, that's where you get some leverage, and they come to the table for settlement. Yeah, I think that's my answer to that.
So you need to know the pain point which you need to press, and at what time.
That's it. Absolutely. We had one case where we had they had paid for the wedding of one of the directors and promoters of the company, and it was a big wedding. It was $5 million spent on this wedding. Wow. And they'd also paid for the daughter's 16th birthday party, and it must have been a big birthday party. It was over $1 million.
Right.
And so we issued proceedings against the wife for half of the cost of the wedding, and issued proceedings against the daughter for the cost of the birthday party. And we made sure they were delivered on the Saturday morning, so when they were sitting down for breakfast. And then on Monday we got a call from the promoter saying, "I'd like to talk to you very quickly."
So you hit the nail at the right time then.
Yeah, that's it.
Excellent.
Exactly.
Thank you so much, Nick. Now let's go to Paul. Paul, Nick made a very important point with regard to looking at the forensic evidence in a way, looking at the outcome, and then you need to know when and where you should press the pain point. Uh, so the outcome which the forensic teams like Iris or Grant Thornton brings out, you as a counsel in UK, I want to pick up your brains, and especially from the UK law perspective. Uh, the findings of the forensic report or the investigations which are being carried out by the private investigating agencies, to what extent would they be admissible in evidence in the UK court?
Well, thank you. Firstly, thank you, Amit, and just to say it's a real pleasure to speak today and join everybody on the panel. But in terms of answering those questions, it probably takes a couple of forms. Firstly, is as Nick has rightly said, it's about at the outset understanding where all the assets are, understanding where the potential points of weakness may be in a particular structure that is being created, and then aligning that to the potential civil remedy that may be available to attack those structures and enable recovery. So that's the sort of start point, and it's very much a collaboration piece at that time between the legal side and the forensic side, understanding what the playing field is, and then putting a strategy in place around that. And then in terms of the admissibility, there's a number of times at which it is required that under English law, making certain applications, you would need to evidence where assets are, that assets were available to enforce against in order to secure particular remedies before the English courts. One obvious example being an application for a freezing order, so evidencing that there are assets within the English court's jurisdiction. So that type of information that the forensic teams can gather enables you to then support those applications. It also enables lots of other sort of spin-off sides to that as well. Looking again at the sort of freezing order application, you'd be looking to make that application in circumstances where there is a risk of dissipation of assets by promoter. And obviously you need to know firstly where those assets are, have some understanding of how they have developed the structures around themselves, how the assets have been moved. And picking up one of the earlier points about that sort of novice promoter who is coming in and moving things as times begin to get difficult for them, then that information is very important in building that picture to say, here you have individuals who are now moving assets. There's a risk if we don't get the order that we're seeking, more assets will disappear and there will be less assets available for the party to enforce against and recover in due course. So that information has many different uses. It's extremely beneficial and something that is something I think is always sensible to get at stage one of any review and project looking at an enforcement action to recover assets.
Thank you so much. You made a very interesting remark with regard to the freezing order, and we'll just come back to you on that. Before that, I would like to just pick up brains of Mr. Sinha again. Mr. Sinha, we have heard many a time that one of the celebrities or a business tycoon or a very famous media editor or a journalist had been stopped at the airport while he is leaving from India because of some lookout notice. Could you help our audience to understand what is a lookout notice and which regulatory authority basically issues that lookout notice?
Amit, first we need to understand that India is a free democracy and everybody has been given a fundamental right of movement. Absolutely. So stopping anybody means curtailing their rights or fundamental rights. So it has to be used very judiciously. And there are certain laws, especially related to foreign travels. I will not be specifically dealing with those laws and acts. Sure. And whereby any Indian is entitled to move anywhere, but subject to certain restrictions. One restriction is that the person should not be required or answerable to any particular court in India at the time when he is planning to leave. And there is a reasonable doubt that the person may not return back. that could be one of the reasons when a lookout can be issued. Apart from that, when anybody is required in any particular criminal investigation by any of the investigating agencies, that particular person can be stopped in India from leaving its shores, or there could be a reasonable restriction of his movement even within the country. So based on those, it is also on the judiciousness of the investigating agency, and these kind of powers are to be used very sparingly, and especially in connection with the fugitives, or not even fugitive, in connection with the suspects who are very likely to leave and have means and ways whereby they will not be returning back to answer any of the courts, and it will require a very tedious process to bring them back. And this power is not only with the police, this power rests with multiple agencies. And now recently the government of India has given this power even to the financial institutions, where a large amount of loan money is either in NPA or likely to be NPA. So going by the experience faced by the certain agencies and by even the financial institutions, the government from time to time has come out with guidelines that when and how these kind of lookouts can be issued. There are multiple lookouts, not only to stop a person from leaving India, even also to intercept a person when he is coming to India. He could be anybody, not only necessarily an Indian, he could be any national. So this though is a law for India and based on the fundamental right granted in the Indian constitution, but also it empowers the investigating agencies or prosecuting agencies and financial institutions even to stop a person of a foreign nationality from leaving the country.
Okay. So the clue that I take from you is that the power to issue lookout notice is not only with the police, it is with multiple investigative agencies.
Correct.
Okay. Thank you so much for this. Mr. Ramasamy, I have one question to you, sir.
Yeah.
While dealing with the international white-collar crimes, how do you liaise with the parallel agencies, both in India as well as abroad? And what is the level of cooperation? And how could it be made better? Because a crime which could be falling under the Prevention of Money Laundering Act could be investigated by the Enforcement Directorate, but at the same time, it's also a crime under the Indian Penal Code. So Economic Offence Wing is also working onto it. There could be a scenario that the person has left India and is being now looked or traced by Interpol. So there is a lot of agencies which gets involved. So how coordination and work in cohesiveness happens? Over to you, sir.
Yeah, we have a kind of a mechanism called the Central Economic Intelligence Bureau, I think, where more than 25 agencies are represented, and it is there in virtually in every state. So including the state investigating agencies and central investigating agencies. All of us sit together once in 2 months to share intelligence, and especially the kind of bigger frauds that we have. So we do kind of know that what kind of an asset position that we could recover. And each agency has their own kind of a process of recovering and tracing and attaching those assets. So we share that kind of an asset statement among all the agencies. In one of the big cases that, we used to have a special coordination meeting also with agencies and consortium of banks, which are represented by a particular bank. And then we try to kind of switch those, the statements of assets that are frozen by each one of them to make sure that, every agency has properly been briefed of the assets available, as well as they taken a legal remedial action to recover the same. If I come to this kind of, that like Ponzi schemes and the multi-level marketing schemes, at the state level also, in the state, we have a kind of a state level coordination committee meeting with including Reserve Bank and other agencies headed by Chief Secretary, that we have a coordination meeting for those bigger scams and frauds, where each investigating agency, like in the case of the registrar of cooperatives would do, with the cooperative banks are involved, or societies are involved, registrar of companies is involved in that. I think AD is involved, CBA is involved. So the police investigation, the police chief is involved. So all those agencies sit together and we kind of look at the progress of whatever the assets that they could kind of trace and recover and attach. Basically, the motive of all those agencies, is to understand that, how the money trail has happened, because we make a very extensive report on that, because it has to go through the banking channels. If some audit is done, and then we get to know exactly that, how the money has been collected, how the money has been siphoned off. Even if there is a multiple layers there, we know the guy that was taken that withdrawal, and then we can go after him. He is going to be in India. It's not that everybody goes out, and all these associates are very much there. And if in case, if it is an international asset, then we have a lot of mechanism. Like I told you that, already we have a data sharing mechanism with automatic exchange of information with India that we have with many countries. We have common reporting standards. Through that, we get information on a regular basis. Through the FATCA, we get some information. In the US, we have been really successful with a good number of cases on FATCA. And we also use this kind of, the DTAA, the double taxation avoidance, to get the information specifically. My experience with some of the mining companies based in Goa and northern Karnataka is that those people who are about to flee the country, or already they've got dual citizenship and all that, we got to know that information from those concerned countries, that what kind of annuity they created. In one case, they created a huge insurance policy, something around, that couple of $1 million in the name of the family members and children. It should benefit them perpetually. So there are instances, that information that we could write to that particular country, and then we get that information. And citizenship, whenever they acquire citizenship in some country, that what kind of a payment they made, in whose kind of, through which account that it has gone there. And that also becomes a violation under MHA guidelines there, holding a dual citizenship. So we kind of, track these kind of information. Like I think Nick was saying that one of those cases that where you use the social media to get to know somebody posing with a yacht. We know that where that yacht is, then we know the registration of yacht is regulated. We know from there, that it is worth about $4 million. So we have some kind of issues that, where we did get those kind of, that asset recovery. First exercise is something like, up the head. We can't really get anything there. Then we should map all those people that who are involved in this, the relatives and associates. Then you start identifying the countries where the asset could be. Then you start making a request to each of those countries specifically, because they also want a specific information. I can't do a kind of an exercise, roving kind of an exercise saying that, no, give me that. So I need to be a little more specific with the companies or the names or beneficiaries or private discretionary trust that is there. I think it's working out pretty well. Benami front in India, we have been doing a lot of tracking, because we have two important legislation that has come in, is the Benami Act as well as the Black Money Act. So earlier, I don't have the kind of, that leeway to go after the Benamidas. Now I'm in a position to identify the Benamida. I just have to catch somebody that who is holding that asset, which is a fraudulent asset. He has no means to explain that, because his income tax return doesn't show that he is capable of owning that asset, and he doesn't have means to own the asset. So I can call him Benamida and I can attach it. So similarly, the Black Money also, that act is helping me, because that allows me to equivalent amount of asset in India, I can attach and proceed against that person. The moment I get to know that there is somebody having a bank account or asset abroad, even though I'm not in a position to attach it quickly and recover the asset, but I can recover the equivalent amount in India, which in any case that we'll be in a position to locate. So to an extent that I find this seems to be pretty working well. One issue that I want to highlight is about the Bitcoin, because we have had some instances in some of those, that Ponzi scheme guys investing in, Bitcoins. So we have had a little bit of a success with, some of those search cases that where we did identify the Bitcoin wallet, and then we are able to locate and ask this guy himself. I think that he was kind of, helpful to kind of get that money back to us. But, the difficulty is that sometimes, if we are not able to identify those Bitcoin investments, we need to use a lot of tools to find out that where it has gone, how it has gone, and where it is being kept there. That's a bit of a tricky kind of a problem that, we are also kind of trying to use some kind of tools to see that how best we can identify it as a part of our SOP in all our search and seizure operation.
Sure. I could see in the chat box that there are some questions specifically being pointed towards you with regard to the Bitcoin, which we will take at the Q&A session. But I just want to now go to Gary, because you talked about Benami, you talked about asset being held by a proxy, because asset could change hands. So Gary, a question to you. In view of the sophisticated asset dissipation structures being in place, to which you said sometimes lawyers, sometimes chartered accountants should also be held responsible for that, an asset can change character multiple times. How do you trace such an asset?
Well, yes, I think maybe even at the sake of repetition, like I said earlier, it ends up being a mixture of science and art. And as Mr. Ramasamy was also saying, your start points can be sometimes very, very limited. But as far as if I personally have a case that I want to work upon, uh, the most wonderful thing that is available to me as information is that there's an human on the other side.
Right.
So if there's a human on the other side, I need to study his mindset.
Yeah.
His mindset tells me all. So a lot of time I've seen, at least on the private investigation side, people have made a process. They'll say, I'll check 5 things, whereas they're not checking the main man who's the human on the other side. So I prefer to go human route. So check the mindset. You sometimes can even look at recent travel records to identify where the assets can be. Sometimes you can actually look at the preferences. As we were getting comments earlier about Ferrari and the villa, a lot of information on social media and open domain. And another thing that comes very handy, and something which is often ignored, I will say, is going to something that I call X factor. What I mean here is that if you go to X employees, X vendors, X clients, there is a lot to it. So if you go to the present girlfriend and the boyfriend, the information shared can be very positive. If you go to the ex-boyfriend, ex-girlfriend, ex-husband, ex-wife, the information can be really rollicking for you. So a lot of time we rely upon this X factor to get very, very relevant leads. I will not call that these X are in position to give us perfect evidences and results, but they give you wonderful leads. So that's where you need to start from somewhere. So start from the human mind, look at some of the people who have been closely working there, and possibly if they left, they will not mind or hesitate talking about the situation and some of the leads that can be helpful to you. Then immediately comes from there is, like I said, some of the people start moving their family members to particular locations. So spread of family, and that too a recent movement, is a very good indication of the direction where the funds could have flown. And in fact, while working very closely with the government investigative agency, we could trace someone who was going to attend his son's graduation in USA. Similarly, we were working for an Indian bank, and we could find out there's a particular person who ended up being in Africa, and the bank mobilized through Ministry of External Affairs, CBI. He was brought back to country. So I'm so glad that in last, let's say 5 to 7 years, the tangible results of the law change, of the wonderful investigations being done are very, very visible. A lot of cases which are being talked about now, well, like I always say, it's a situation of, as we call in India, chor police, thief and police. The thief has to run ahead, and police has to keep at a very close distance, so that you can closely monitor and nab whatever goes wrong. Police will never have the luxury to run ahead of the thief. Then the thief can change direction and you don't get to know where he's gone then. So this will be a challenge, that thief will have the luxury of being a little bit ahead, more innovative, but at the same time, having the understanding of human nature, knowing the nearby areas, and these days, most of the money travel through wires. So monitoring, and as well as the end destination, unless a specific dark zone of tax haven is used, is also very much possible. So I think that's where, like I said, mix of science and art. So we keep at a close distance, keep watching the guy, because if the case has started becoming NPA, that is the best time. The person is, like I said earlier, creating various securities, creating various funds for fighting the battle and stuff. Just watch them closely, and you will surely have the results available.
So it must be like a feeling like a Sherlock Holmes trying to solve a story.
More than that, because Sherlock Holmes is only you see, but like all of our team members are on ground. So it's more than a 3-dimensional, it's a 6-dimensional situation we are in.
Absolutely. Thank you so much. Now I will go back to Paul, and Paul, I'll continue on the point of the freezing order which you mentioned, because Mr. Ramasamy mentioned about assets being held by relatives, proxy. Gary spoke about asset changing hands. You talked about the freezing order. I would like you to delve more on what is a freezing order, and can a freezing order be obtained at this particular juncture while a civil or a criminal prosecution is going on in India, and I feel that, oh, I have found an asset thanks to my investigating agencies. There is an asset. There is a strong possibility that asset can dissipate it or can change hand. I need to lock that asset and connect it to the person. So what is this freezing order all about? Over to you.
Thanks, Ahmed. It's a very interesting and powerful tool that is available. There are obviously different variants of those sorts of orders in different jurisdictions, but looking at the English variation on a freezing order, it can take a couple of forms. It can either be a freezing order in jurisdiction, so purely limited to the jurisdiction of the English and Wales courts, or alternatively, and this obviously is when it becomes very powerful, is it can be a worldwide freezing order, and it can have its restrictions across the globe. And what it essentially is doing, or will do, is it's an order that is put in place to preserve assets pending an enforcement stage by a party. So it effectively preserves that asset picture such that as at the time they are able to go and enforce, then those assets are still there and haven't been dissipated by the target. So picking up one of your questions, do you need to have a judgment in place? No, you don't even need to have issued proceedings. As long as you are confirming at the time that you make the application for a freezing order that you would be issuing proceedings within a reasonable time. And in that context, a reasonable time is very quickly after you've made that application, that you would be pursuing those proceedings, then that will be sufficient in that context. And then sort of picking it apart and how it works. As I say, it's a very powerful tool. That places a lot of restrictions upon the target. So in its component parts, it restricts the amount of money they can spend. They can't obviously dissipate any of their assets. If they do so, they would be in breach of that order and would be subject to the sanctions available under it. So contempt of court, potential penal sanction as well. So it's a very risky game for a party who, once they are served with that order, if they breach it, then there are obviously pretty significant consequences that would follow. In terms of the sort of steps, there are a few steps that you would need to take in terms of getting an order before the English court. So you would need to be firstly confirming that the English court has jurisdiction to hear the matter, and that can arise in various different ways. An obvious one, and one that we have seen in a number of instances, is where the individual is here. They've left India. And they're sitting within this jurisdiction, obviously a fairly popular jurisdiction for parties to flee to. So that's an easy way in. There are many other ways, and obviously will depend on the particular circumstances of the case. Application, then you've got to show that you've got a good arguable case with that underlying claim that you have. So that claim, again, doesn't necessarily need to be pursued in England before the English courts. It can be a claim that is pursued before other courts. So we have secured freezing orders where the relevant claim was pursued before the Indian courts. As long as you tick the other boxes, then the English courts are prepared to entertain that and grant the order in those circumstances. Point that I mentioned before, existence of assets within this jurisdiction. So assets in England and Wales, which is where that forensic investigation piece comes in as well.
Yeah.
And there are a couple of things that I think are probably obviously then building. So the other important point is the risk of dissipation that I mentioned before, and that is a high bar. So you have to show that there is a real risk of dissipation, not just a fanciful risk, not just a concern that it might happen. So you have to evidence to the court why you have that risk, what the concerns are. There are other parts that you have to give to the court as well. There's a cross undertaking and damages that the applicant has to take, which is reflective of the serious nature of that particular order. But once it's in place, it places restrictions upon not only the target, but anybody who is served with that order as well. So if you're serving the banks who are providing facilities to that individual, then it places them on notice. If they assist that target in breaching the order, then they equally would be in breach of the freezing order. So it's one that spreads its tentacles out very quickly and is very powerful as a result. And picking up your other part that you mentioned in terms of the asset structures and the way in which they are held, it is possible to secure, and again, something that we've done, it's something called a Chabra defendant under English law, reflective of the leading case in that particular area. And what it does is it enables you to join third-party vehicles who you consider to be holding assets on behalf of the target individual, so they are put on notice of those proceedings as well, even though they may not be parties to the underlying claim that you have as against the target individual. So where that individual is has a series of corporate structures that hold various assets for him, you can join those particular vehicles, so they are expressly put on notice of the application to then restrict them as well. So it's a really useful tool, something that is a very powerful tool, and as I say, continues to assist all the way through that enforcement process because of the restrictions that you've put on the spending limits, the spending power of that particular individual, their ability to use the assets that they have. And they also have to, at a very early stage, normally within 14 days or so, provide an affidavit to the court of their assets. So confirming all the assets that they own. So you have then a list that you can work with, look at, take steps to preserve, take steps to enforce against as and when you get to that point as well. So a real goldmine of information and a powerful tool that is available, but a high bar because of the draconian nature of the powers that sit within it for the courts to be prepared to grant such an order. But if you can get one, very, very useful as part of these sorts of processes.
Understood. Thank you so much. This is very interesting to have a freezing order so that you can protect an asset before you get the civil decree for the enforcement. Very interesting. Paul, before I move to Nick, one quick question, and I am not sure whether you will be very comfortable to answer it, but I need to ask this because a lot of people, I'm sure, in the audience would like to hear it from you. To the extent the information is in public domain, could you share with us where are we with regard to the famous Vijay Mallya's matter with regard to fight of Indian banks of recovery? If you could throw some light on the matter, which is to the extent it has been public domain.
Yes, I can certainly update. Obviously, we're acting for the banks on the civil enforcement, so aren't engaged with the extradition process. So can't comment on that, but I think everybody is aware of the reports in the press and the suggestions that he may be claiming asylum to try and avoid extradition. So that's one element of it, and that is continuing to run its course off to the side. In terms of the civil enforcement, our action is ongoing. We secured the registration over 2 years ago now of the DRT judgment that the banks had secured in India, had that registered with the English court such that we can then use any of the powers of enforcement that are available for effectively an English judgment are then available to us in respect of that judgment as well, because it's recognised by the English court. That process has been ongoing, but as part of that, we have issued a bankruptcy petition, and that bankruptcy petition is currently ongoing. Again, there would have been, I'm aware that there were press reports that picked up on the fact there was a hearing in respect of the bankruptcy petition last week. Judgment in that particular element has been reserved. There was a judgment a few months ago at the start of the year in respect of security or security that the English court has found that the banks hold over certain of his assets in India. This was a follow-up application in respect of that, seeking a dismissal of that application of the bankruptcy petition on the basis of the discretion that the judge has in circumstances where security had not been declared at the time the petition was issued. Judgment on that is reserved at present. Anticipate it will be. The judge gave an indication at that hearing that he likes to have his judgments written within 2 weeks. So a very quick turnaround on that particular one. So anticipate that the judgment will be handed down in the near future, but that bankruptcy process is ongoing. It is as would be expected, a heavily contested process that is currently ongoing at the moment. But progress has been made, certainly through the couple of years since registration of the judgments happened.
Right. Thank you so much. I am getting messages from Nipun. He's staring at me, but I would not end without asking my last question to Nick. Nick, here's my question. And sorry, it could sound a bit difficult one for some of my audience, but I need to ask this because that brings a lot of thought process onto the table. Nick, you have been an experienced asset tracing specialist and an insolvency professional. How often have you come across a scenario where a role of a banker or other intermediary is also checked in the process of money being laundered or siphoned off by certain promoters? I'm not saying all promoters are bad. I'm not saying all bankers, intermediaries, lawyers, chartered accountants are bad, but there could be something which would have been done by someone as an intermediary, because then money has moved by wire. Over to you.
Yes. Well, when we look at when we look at trying to recover assets, we look at all the possible avenues. So we look at bankers, we look at lawyers, we look at auditors, accountants, and some of the specialist layering providers that some of the Indian promoters like to use. So there are specialist consultancy companies around the world who will assist people in hiding their assets and will provide nominee directors and offshore companies and offshore trusts,
company administrators, trust administrators.
Absolutely. And if you can get into those, that's a really good discovery exercise. But yeah, I mean, we look at everybody who might have had a hand in the transaction. We call them enablers. And they can be in any professional who's been involved.
Okay. Thank you so much for this, Nick. Thank you so much. Nipun, I must thank all the panelists for this. Thank you so much, my dear panelist. And now over to you, Nipun, for the Q&A.
I think the sheer fact with the amount of questions we have in the chat box, I think it's visible the fact that everyone's kind of really finding the discussion very interesting. But good that now we're straight away moving on to all the questions that we have reserved for our esteemed panelists. I'm going to first go to Mr. Sinha for this question, which has come from Mr. Amin Dhani of RBL Bank. The question reads, in case a private sector bank traces assets abroad, how can these assets be encashed and recovered by the bank? Any of your thoughts on this?
I would like to state that when it is a matter of a private sector bank, the route is very similar to a public sector bank, because as far as the banks are concerned, though the categorization is there within our country, internationally, most of the banks are held in a private domain. So there is no difference as far as tracing the assets and recovery of those assets are concerned. But to add further to it, as I had stated at the very beginning of my participation in the webinar, that the golden hour is lost. And that we have seen happens more frequently with certain private sector banks. And it could be the experience everywhere. The dilemma to consider it an NPA or to brand it as a fraud. That is a bigger dilemma that the banks especially face. And now with the strict guidelines which has come from RBI, Reserve Bank of India, to an extent the situation is very clear when it can be classified as fraud. So why I am delving on this subject is that the route to trace back an asset depends very much on the fact whether it is an NPA or it is a fraud. So going to the basic question whether how to recover these assets, I think the mode of recovery is very similar to what it could be for the public sector bank. To elaborate it further, there are certain offenses in the Indian system which are called as predicate offenses under PMLA. So most of the offenses which fall under the white collar crime are predicate offenses under PMLA. So when an investigation is done by any of the economic offenses wing across the country or even by the CBI, after the registration of the FIR, a parallel investigation is started by the Enforcement Directorate under PMLA. So these parallel investigations take both routes of tracing the assets within the country and abroad. And we coordinate and we ensure that most of these assets are recovered. There are very many examples, but I think it could not be in the scope of today's meeting to discuss all these issues. But yes, there are ways and it can be done, and it is being done.
Thank you. Thank you so much, sir. Thank you so much. Mr. Amit Agarwal, we've heard you steer the panel, but we have some questions for you also. So I'm directing this one straight away to you, Mr. Agarwal. There have been cases, this one has been sent by Mr. Yogesh Kapoor from Mashreq Bank. He's said that there have been cases where company has gone into insolvency and lenders have ended up recovering their monies from the new buyer and settling amounts. While there have been allegations of siphoning off on erstwhile promoters in such cases, however, since banks end up settling their claims with a new buyer, does that mean that criminal proceedings initiated against the promoters will get dropped, or how do you go about it?
So the criminal proceedings against such person will not get dropped. What that person has done is basically done a breach of law. If it is subject to a liability or a prosecution under the criminal law, even if you have done a transaction whereby the liability may have extinguished, he will still be held liable for the breach. So yes, criminal prosecution will continue.
All right. Thank you. I'm directing the next question to Mr. Ramasamy. Sir, there's been a question for you from Mr. Gyan Pipara, managing partner of Pipara and Company LLP. He's mentioned that fund transfers or movement of funds require transfer of funds from one account to another. Of course, as a natural corollary of such fund movement is involvement of banks. How often have you found deliberate involvement of bankers in monies laundered or siphoned off by promoters?
Yeah, I think this happens, in most of the cases. Even no fraud can be committed by, someone around. Someone mentioned that, they also engage law firms and chartered accountants to perpetrate such big frauds. There are a lot of people who are involved in the process. During SEBI days that I have also found that, in every kind of a market manipulation, you have some broker involved and promoters involved in that. So the similar case, here also we do find in many cases that, the banks are actively aiding and abetting the crime. So we have also launched some kind of, the prosecution against the banks. Primarily the problem with the banks are that, you do find them that they don't report properly. If you look at it, that there is some high value transaction, which law requires you to report. There is some suspicious transaction, like an STR, we call it, suspicious transaction report. Had they kind of informed me earlier, then I could have kind of even, dealt with it at an early stage of the crime. So at that stage, the reporting itself is costing heavily. If you look at it and you allow the fellow to open multiple accounts, launder money and with multiple shell companies, which, apparently, I don't think that any banker would be so kind of naive to allow such transactions to do that. So we have seen in many cases, I think, that where the bank has not done the due diligence on KYC, or they have not kind of, reported it as part of the suspicious transaction reporting, or maybe if the person is a politically sensitive person, if they have not reported that under that, I think we have also taken kind of an action. Because actively aiding and abetting tax evasion or money laundering or, the helping the person to flee, I think these are all now being brought part of it. Even if you look at this amendment to Companies Act and PMLA and even Income Tax Act tax evasion, now that aiding and abetting has become an important issue. So that's one of the important ingredients that we did find those professional kind of, that agencies or intermediaries being part of it.
All right. Thank you so much, sir. I'm going to move my next question to Mr. Nick Wood. This seems to be an interesting one. It says that so the question has been sent by Mr. Dhananjay Shahi, Deputy General Counsel at Flipkart. He's asked that other than banking and financial sector, which is of course now increasingly using the services of forensic auditors, which are the other sectors which are increasingly falling back on forensics for their functioning? Mr. Wood, you'll have to unmute yourself.
Thank you. Yeah, we're finding increasing inquiries from large corporates who have suffered fraud themselves, either internal or external fraud, and they want us to investigate how those frauds have occurred, and then assist with recovering those monies. And the second aspect to that is having learned how the fraud occurred, what business processes they need to put in place to prevent those frauds happening again. So yeah, large corporates is probably our biggest space, and in these COVID times it's happening more and more frequently. So yeah.
All right, thank you so much. I'm going to direct the next question to Mr. Singh. Mr. Singh, this question has been sent from Advocate Joydev Sen Gupta. So a lot of the cases are multi-jurisdictional cases. So when you're dealing with such cases, what kind of challenges you face with respect to, let's say, data protection or privacy laws, especially when you're dealing with a case that has overseas jurisdiction? What kind of challenges have you faced when it comes to that?
Well, I think they do look challenges in case we are less informed. They're not challenges in at all in case you have the full knowledge of the local laws. So if you're in India, you need to follow everything which Indian law says. And if you are, let's say, in Britain, where the privacy laws are different, you cannot say that my Indian law will work there. Rather, if a British firm tells you to do a job in terms of investigation, or an American firm or anybody else, then you need to be very careful that their laws have to be followed while investigating case, whether in India or somewhere else. So in my opinion, it is the toughest law at that possible point available has to be made applicable, because anything, let's say, if you're talking about FCPA, GDPR, if you're working for those respective countries and you do not follow those particular laws and regulations that have been prescribed, those firms back home end up being liable. So pretty simple, the toughest law at that point of time, and the law of land which you are in. And in fact, maybe challenges for private investigators in these terms sometimes can be less. It's more for Mr. Sinha and Mr. Ramaswamy, because what happens is when they demand information officially from some of these countries, and believe me, this is true, some of these countries under privacy laws don't even share information of tax defaulters, sometimes even the terrorist funds which are being moved. And at the same time, some countries, which we call tax havens, whether it's British Virgin Islands or a lot of other similar places, they actually create an ecosystem to get the funds to their location, irrespective the funds are black, white, or gray, and they do not share any information out. So the challenges are huge once we look at those points. But at the same time, as an investigator, I need to be careful that it's a trail. The funds do not originate in BVI and do not die in BVI. They basically move across those BVI, which are so-called dark zones, to not get traced further. But they will start from somewhere. So even in that case, if they start from India, they start from Indonesia, Malaysia, or the Gulf, let's start from there. And if you find them going to one of the dark zones, it's a clear sign that the promoter or somebody else who's managed that way needs to provide those specific answers. So I will say this side is pretty simple maths. You have the rules defined. Yes, you need to know the rules, and it becomes pretty easy to handle.
Very well said. Very well said. Thank you so much, sir. Thank you. The next question has come in from Saudi Arabia, all the way from Saudi Arabia, by Shaumik Chatterjee, and it's directed to Mr. Paul Gair. A very interesting question indeed. Mr. Gair, it says, could you throw some light on the asylum process in UK? What are the key essentials that UK authorities keep in mind while evaluating an application seeking asylum in UK, and if the extradition process is continuing, whether or not the application to seek asylum will be entertained by the authorities?
I would like to, but I dare say not an area of law, unfortunately, that I am overly familiar with. But so it is a very specialist area. In terms of the extradition process at present, if an individual is running that, and I think in the example that may be in people's mind on it, then the process has effectively ended to one sense. There are one or two avenues that were left open. Potential European Court of Human Rights appeal had been spoken about. So it then becomes a separate piece. The question in all of that is the time at which that asylum process commences. So has it been ongoing? But in terms of the interplay, something I wouldn't really be able to comment on without having had that experience of it. But it is, as I say, something for people to watch and see how that plays out over the next period in respect of Dr. Malia's case.
All right. Thank you. I have the next questions from the chat box, which is directed to both Mr. Sinha and Mr. Ramasamy. So I think I'm going to read this question out, and maybe we can have views from both of you, Mr. Sinha and Mr. Ramasamy. It says, looking at the challenges in the asset tracing due to late detection and reporting of financial frauds, do you think there is a need for some radical changes in the financial laws and the regulations or the enforcement laws, so that government authorities are allowed to act swiftly, or they may act swiftly? And any specific changes which you think would have made the difference while you were doing the asset tracing or investigating a matter? So what's the need for the changes? What changes you think can really fast track the whole progress? So maybe we can have the views of Mr. Sinha first.
I feel that it is, Nipun, like walking on an edge of a sword. If you interfere too much, it will invite the allegations of an Inspector Raj. If you leave it, then it becomes a kind of an act on omission or willful negligence. So there is a classical dilemma, and it exists everywhere. Having said that, what I feel is a key feature which, at least to my experience, I am finding in most of the large frauds involving the banks and the corporates, is the role of the auditors, especially the in-house auditors, concurrent auditors, and the statutory auditors. Because the system has provided for raising the red flags. The system has provided in the case of listed companies whereby all these balance sheets are made public. But if the very nature of the fraud involves somebody where the red flag has to be raised is not raised, then it becomes very difficult for anybody to, as I said, to intervene at the proper time. Apart from that, there are also many kind of evergreening happening, which are happening also with certain connivance of certain banks. I will not blame anybody, where everybody is interested to somehow square off their own balance sheet, to at least get their own loans somehow being catered to, even if it is at the cost of somebody else. So if these kind of factors are there in the market, where even if the bankers are aware that from where the money is coming and what is the situation in a particular sector or a particular company, then it becomes very difficult, because then it is everybody's game against everybody else, my game against everybody else. So these are certain areas. Apart from that, I can also say that certain early whistleblowers, though the whistleblowing law is there, the certain early whistleblowers are very conveniently taken care of. And even if there are laws which exist, the scope of even the concept of the very nature or the definition of public servant now is including even the private banks. The courts are enlarging the scope of the laws. But yes, there are loopholes, and as the time will progress, and as it has been said by Mr. Singh and others also, that it is a game of chore police, and we have to continuously learn, innovate, and evaluate and proceed further.
Thank you, sir. Can we have the views of Mr. Ramasamy as well?
Yeah, I think, I really find that laws are adequate. I don't think we need any more laws to kind of, look at it. But I find that we have more than what is needed. Especially what has come in the last, the couple of years is, really pretty good that, to deal with this kind of issues. But, when something matures into fraud is a big question. Till the time that you don't know that, that guy is settled and then he just leaves. That at the time it takes a kind of part, takes a character of a fraud. So if it is a question of a bank that is involved in this as a victim, I would rather feel that, that bank should do all the due diligence and kind of an alert. Their mechanism, there are enough mechanisms within the bank to ensure that, this guy is going to default on that. If they are not in a position to identify, I don't think they are not fit to be in the business. Similarly, if it involves the public, I would rather find that, there are a lot of people who endorse the schemes. There are a lot of celebrities, sports persons who come and endorse such a scheme saying that they know particularly it's a Ponzi scheme. They know it is impracticable to give that kind of a return. But you do find a lot of advertisements and all of us believe in it that it is someday going to fall. But still, we kind of keep quiet. I would rather find the law may be brought in to see that those people who endorse such schemes to induce those innocent investors or public to get into this kind of a Ponzi scheme or MLM, they should be taken to task a little more, kind of a tough manner to ensure that they have some accountability and responsibility so that the fraud doesn't become kind of, that largely widespread. So we can curb it. Otherwise, investigating agencies normally step in once the fraud is committed. So the thing is that it is a kind of, that we have to look at it at what stage, that we can step in. We don't want to kind of, that disturb the ecosystem that is, kind of making it survive.
Thank you. So I think we are on the last 5 minutes, and I think we have no time left. I'm sorry, we do have a lot of questions flowing in, but at this point, I have to get Mr. Gupta on board, Mr. Rajesh Gupta, because it has been an amazing session, and we say that knowledge is power. So I thank all of you on behalf of SNG and partners. But yes, we have Mr. Rajesh Gupta who wants to personally thank each one of you. So can we have you, sir, and extend thanks to everyone, please. Thank you.
Hi, thank you, Nipun. It is a very exciting session. I wish it would last longer. I can myself see lots of questions pouring in. We'll try to see how to address them. I am very, very grateful to each of the panelists who took time for us. It a very, very valuable insight and very, very interesting as well. Nipun, of course, thanks to you, Bitika, Tejas, for all the support you gave us from Legal League. Much appreciated. I'm also grateful to my own SNG team who worked hard on this webinar. I know we have lots of takeaways from this webinar. What we'll try to do is summarize them, put a note together, share with all the participants. We had like almost like 225, 230 participants. We went down a bit later on, but still we had a significant gathering. I'm sure we are going to share all these insights with each one of them so that they can take benefit of what we have discussed here. Many, many thanks. And thank you once again to everyone, including all the participants. Many thanks.
Thank you.
Thank you. Thank you.
Thank you. Thank you.
Thank you very much. Thank you.
I must say it was fantastic. On the ground, realistic on the ground, on the bang on the subject.
Amit was very excited to have this panel discussion done with all the panelists. I think he's also happy. He's smiling. We'll try to do more, in the near future. Thank you.
Thank you.
Thank you,
Thank you,
everyone.
Thank you, everyone. Thank you.
Welcome.
Video of